미국에서 주재원으로 생활하다 보니 여기 환경 나랑 너무 잘 맞는다. 미국에서 주재원에서 영주권 받기까지 어떤 방법들이 있는지 LA 지사 대표 변호사님 함께 말씀 나눠보겠습니다.
안녕하세요. 토마스 앤&코 강지혜 과장입니다. 오늘은 저희 LA 지사를 총괄하시는 변호사님을 소개드리고자 자리를 마련했습니다. 그동안 수많은 개인들과 회사들의 비자 승인을 위해서 수고가 많으셨는데요. 유튜브로 고객님들께 인사드리는 건 처음이니까 짧게나마 말씀 부탁드리겠습니다.
안녕하세요. 김성은 변호사입니다. 이민 비자, 그리고 EB2 NIW, EB1A, EB1C 담당하는 변호사이고요. I look forward to sharing significant immigration policies and new procedures in the future.
미국에서 주재원으로 생활하다 보니 여기 환경 나랑 너무 잘 맞는다. 아이 교육 환경도 너무 좋다 라고 생각하시는 주재원분들이 많으신데요. 미국에서 주재원에서 영주권 받기까지 어떤 방법들이 있는지 오늘은 미국 LA 지사 대표 변호사님 김성은 변호사님과 함께 말씀 나눠보겠습니다. 안녕하세요. LA 지사 김성은 변호사님은 영어가 좀 더 편하신 것 같아서 영어로 대화를 나눠보는 시간을 가질 거고요. 여러분들을 위해서 아래에 자막을 넣어드리겠습니다. In the previous video, we discussed what the differences are between E2 visa and L1 visa. That's the most common visas that companies send their employees to the United States.
Correct.
A lot of people wonder what the difference is between E2 specialists versus L1B specialized knowledge. I don't think many videos out there already discuss that. So could you briefly describe what the main differences are between those two types of visas?
I think you have to understand that the E2 visa and the L visa are different visa categories. E2 is for the treaty investors. So whether it be an individual or a company who is investing into a business in the US or setting up their own company into the US, it's easier to think about it that way. Whereas the L visa is a company, we are opening up an affiliate, a subsidiary, or a branch office in the US, and we want to send our own employees to work at these companies. So if you do it that way, you kind of get the idea of what the differences will be. L visa, because there is the requirement that you work in the parent company or the affiliated company for a minimum of 1 year within the last 3 years. The specialized knowledge comes from that. I have worked in this company, so I have knowledge about our company, right? Whether it be products, whether it be procedures, whether it be protocols, whether it be even patented information. These employees have that specialized knowledge. Therefore, we are sending them our company in the US because without that knowledge, there is no one in the US who can fulfill that position. With a treaty investor, there's no requirement that that employee had worked for the parent company or an affiliate company of the US. So they're not going to really have that specialized knowledge specific to that company. So what you're thinking is this person is just a specialist in the field, right? They have that much knowledge about the industry, or they had advanced knowledge about, I guess, the technologies or specific information about the trends, and so they are called specialists, and we argue that they have to go into the U.S. because in order for this invested enterprise to grow, to make the investment grow, these people are necessary. We need these specialists. It is also important to show that a comparable person in the U.S., whether it be a U.S. citizen or permanent resident, it's not easy to find someone in the U.S. who has that specialty. Take, for example, we did a case where we sent engineers, right? We sent engineers on an E2 visa into the U.S. Because engineers, you can find engineers in the U.S., right? They're a dime a dozen in the U.S. So what we did was specifically to the area where the company was located, we looked up the job industry, we looked up demographics, and we found that in that state, in that city, there was a limited number of that specific type of engineers. So the company would not be able to have hired someone so easily. Those are kind of the research that we do in order to fit those kind of requirements.
Like I've said in the introduction, many 주재원 employees, they are very interested in getting green cards once they're in the United States. What are the options for those employees to get the green cards?
Well, it does depend on what level they are in the company. For specialists, for essential workers, it's a little bit difficult. If the U.S. company is willing to sponsor their green cards, they would have to go the employment-based route. The employment-based route includes Eb1C, Eb2, and Eb3. The specialists and the essentials, they don't really have a choice of what, they can do the EBC or Eb2 or the Eb3 route, which does take a long time currently. Probably it'll take them 4 to 5 years to get their green cards. But for executives, managers, supervisors in that position, it's a much shorter route. I'm not going to say it's a simpler route, but I'm going to say it's a shorter route because the Eb1C categories are for those who are multinational managers, multinational executives. That being said, multinational, what that encompasses is that whether it be with the parent company in Korea or whether if the company has other subsidiaries or affiliates in other countries, this person has worked in another country, but also they have worked in an executive or managerial capacity in the other country as well as now in the US. Now, with the Eb1C, you don't need a petitioner. You don't need a sponsor to petition you. So you don't have to say, oh, my company is going to sponsor me. But it is necessary that you are working for that company because you have to prove that you are a manager. So in that sense, you don't go through the perm process. The perm process is not necessary. You can basically restart with submitting your petition to USCIS. Now, the Eb1C category, you're going to say, well, what managers, what executives qualify for those positions? It's not just CEOs. It's not just, people at the very top of the organization chart, you would say. It's for any managers who are in the capacity of a personnel. We divide it into two: personnel management or functional managers. Personnel managers are those who supervise people. Okay, so you have maybe human resources managers, or you those people who directly have subordinate employees that they are managing. The other type is the functional managers. Functional managers do not necessarily have to have subordinates. Functional managers is to show that in a department you can work alone, but you are in a capacity of a manager, meaning that you have power to make decisions, right? You have the power to direct the direction of your department, things like that. So basically, when you're looking at the manager executive position, is basically what power do you have? Do you have a lot of decisions up to your own discretion, or do you have to keep going through people in order to get things done, things like that? Or do you have the power to make policies, procedures that the company will eventually adopt, things like that? So the Eb1C, if you are in a position in the U.S. and you were in that position in a foreign country, you can apply for a green card under the Eb1C category.
Many people often say Eb1C is for the manager of the managers, the top manager you have to be. Is that necessarily true?
That's not necessarily true. As I mentioned before, if you are in a manager position, a supervisory position, how much power you are granted, you're given by the company, I guess things that you can do in the company based upon your own discretion, those are the things that are going to make you a manager. And so let's say we've had clients like, they're just project managers. Project managers are not top of the top. They're not even part of the, top of the hierarchy in the company. But we have had project managers apply for Eb1C because the thing is, we need to prove that you have autonomy, okay, within the company. And there are certain project managers who do have that. Right. When they are given a project to handle and manage, they are making the decisions, right? They are determining what direction the project is going to go. In that sense, project managers can apply for the Eb1C. But saying that, I'm going to say that just because you have manager in your title, just because that you're given some autonomy in what you do does not necessarily mean that you are going to qualify for the Eb1C. That's why we always start off with our clients whenever they want to apply for the Eb1C, that we always do request your CV for one, the organization charts of your company, and then basically what your duties are. Your duties and responsibilities are at your current company, as well as in the past at the parent company. So based upon our review of that, then we will determine if you are qualified for the Eb1C green card.
On that note, how about if your E2 company is very small, like relatively small, that they have very few employees, could you still apply for Eb1C?
Sure. I mean, like I said, it depends upon what your position is, what your duties are, what your responsibilities are. There are companies in the U.S., foreign companies set up companies in the U.S., but they're not going to have a full staff of 100, 200.
Right.
They may have that here, but in the U.S., it may not be necessary for them to have that many employees. So, like I said, it's going to be based upon what your duties and responsibilities are and how much power you are given by your company to carry out those duties and responsibilities.
Right. It always goes back to, it depends.
It all depends.
Yes. Lastly, I think a lot of our E2 clients would be curious. You know, often we emphasize that E2 visas are non-immigrant visas.
Correct.
You have to show your intent to depart the United States upon your expiration of your visa. Can they still apply for Eb1C, which is a green card? Would that be a problematic?
No, that's not a problem at all. Like I said, the L visa is much easier for you to apply for the green card just because it's not, it allows for the dual intent. But whereas the E2 visa is a purely non-immigrant visa, whereas you don't have the intention to immigrate to the U.S. However, a lot of people have spoken about the 90-day rule. Okay, the 90-day rule is not a law. It's a guideline given to immigration officers to determine whether or not this person had the intention of immigrating to the U.S. when they applied for the E2 visa. Now, the 90-day rule has been eliminated since 2021. However, many immigration officers still use that number to determine whether or not. So what that 90-day rule means, you enter the U.S. with the E2 visa, and then after you wait 90 days, you can apply for a green card. That's kind of the guideline. That's kind of what people are saying. However, nowadays, immigration officers are looking at the totality of your case. When you look at the totality of your case, did the person really intend to stay on it temporarily with the E2 visa? Now, with the E2 visa, the intention to not immigrate is very simple. You can prove it just by stating in the cover letter, the applicant does not have any intention to immigrate to the U.S. That satisfies that requirement. But once you come in and you apply for a green card, what does that happen? Did you lie? No. We can explain circumstances changed. I did come here temporarily, maybe to work for a year or two. However, our business has expanded so much that it is requiring me to stay longer. Or we haven't been able to find employees who can perform the services or the duties that the E2 visa applicant has. When you explain those circumstances, that's enough to satisfy the immigration officer. This person really had no intention of coming to immigrate to the U.S. Now, I am going to say one thing. A lot of times people say, okay, I'm going to apply for my green card. However, I'm going to go back and forth with my E2 visa. Once your application for immigration has been submitted, we do advise our clients that they do not travel back and forth from Korea on their E2 visa. Because every time you come in to the U.S., you will be asked, you have filed for immigration. Is that your intention?
Right.
And that can cause problems. So once your documents has been submitted to USCIS, we do recommend that you stay in the U.S. until you receive your green card, if possible.
오늘은 많은 주재원분들이 궁금해하실 정보들을 저희 김성은 변호사님과 나눠보았는데요. 저희가 평소에 다른 영상에서 접하지 못했던 정보들을 알 수 있는 시간이어서 많은 분들이 유익하셨을 것 같습니다. 김성은 변호사님 오늘 좋은 말씀 나눠주셔서 너무 감사드리고요.
감사합니다.
다음번에는 더 좋은 정보로 찾아뵙겠습니다. 감사합니다.
Thank you.